Okay, so bonjour tout le monde, bienvenue. Good morning, everyone, and welcome to Osgoode Hall Law School. And for all of those of you who are accessing today by webcast, welcome as well. As some of you may know, today's event is being recorded and it will be posted on iposgoode.ca. I'm Professor Giuseppina D'Agostino, and I am the founder and director of IP Osgoode, Osgoode Hall Law School's IP and Technology program. On behalf of IP Osgoode and Osgoode Hall Law School, thank you so much for joining us today to our event, Sparking Innovation with Students, as you see, examining the role from invention to commercialization. Now, today's conference is especially it's a special one because we are co-sponsoring it with the Canadian Intellectual Property Office. And we're very grateful to CIPO for its support, and we'll be hearing from its helm quite shortly. We've never hosted a conference, and I should say this, that as soon as we sent out the epigram, so the epigram is our weekly student newspaper, the comment that was had by most of the recipients was, what a great idea for a conference. So good idea. Now, of course, this is not to undermine any of our past events, because I think they're all great ideas, but what I do think it does is really highlight the fact that there is a need to have this conversation. In our daily vernacular now, we talk about innovation, commercialization, technology, all the buzzwords, but I think we do need to focus the spotlight squarely on a very talented group that is often forgotten, and that is the student. So the students, they come in all shapes and sizes, as we'll be finding out today throughout our sessions. And in many ways, for me, the idea for this conference was very much inspired by my work, which is funded by the Social Sciences and Humanities Research Council of Canada, which deals with triggering and fostering innovation through intellectual property law. Another reason why this conference is here today with us is that it was very much animated by past events that I've been at where they concerned students, but there was really no student in the room to be found, or at least some of the people in the room had forgotten that they were in fact students, so that you needed more of the student perspective to animate that discussion, and especially to react on some of the policies that we have in place and some of the attitudes that are in place at key commercialization outfits in this country. So I find this quite tragic, especially when we overlook the student, but really the student and youth generally, they're really the raison d'etre for what we even do here at the university. So without them, we would not exist. So what I hope today will do is to begin to rehabilitate this conversation and to really introduce the student back into the equation and to really see how we can better include them and have the system also work for them. Now, students are, of course, pivotal to this whole process from invention to commercialization, and I could just give you some examples, and we'll be seeing some of the examples on the student panel, but some of the famous ones that I'd like to remind you of, Charles Best was a medical student who co-discovered insulin with Dr. Frederick Banting. Sir William Lawrence Bragg made his discovery on the diffraction of X-rays caused by crystals. This, of course, is Bragg's law. During his first year as a student at Cambridge, 3 years later, he was awarded the Nobel Prize in Physics, and he was only 25, and he shared this prize with his father. Now, the principles, of course, established by Bragg's law have been used by scientists to elucidate crystal structures, including the DNA double helix. And of course, this is really the birth of molecular biology as we know it. So pervasive across the world. All from Sir William Lawrence Bragg. And as a third example, I'd like to highlight Bill Gates. We hear a lot about Microsoft. We'll hear from Microsoft later today. And more recently, Mark Zuckerberg, the founder of Facebook, of course. And they both started their tech empires as students at Harvard. So this conference really seeks to give a voice to students, and that's really what IP Osgoode is all about, is to inject many more voices to enliven the IP debate here in Canada and around the world. And one of IP Osgoode's goals, and it really is to augment the learning opportunities for our students. And we have many activities here, but if I could just highlight one, and that's the Innovation Clinic that we started. And this is a partnership with the Ontario Centres of Excellence, which is the tech transfer hub of the Ontario government, which acts as a gateway between the government, industry, and also academia to facilitate commercialization. So we've partnered with the Ontario Centres of Excellence, also with a leading law firm, Torrey's LLP, so that our students do hands-on work and they work with other students who have those dreams and want to commercialize their inventions. And they work together to make this happen. And they do the work for free. So this is sort of one small activity that we're doing to contribute to this area and also have the students very much involved. So for today's conference, it's really an honor to welcome a distinguished cast of speakers and also members of the audience, in which I look forward to seeing you very much engaged and asking lots of questions. Now, of course, we couldn't be here today but for the support of our sponsors, and I mentioned CEPO, I mentioned SSHRC. I'd also like to highlight IP Osgoode's founding sponsors. So we have two industry sponsors, the Canadian Copyright Collective and the Audiovisual Licensing Agency, and 5 founding law firm sponsors. So Castles, Gowlings, McCarthy's, Norton Rose, and Oslers. So it's because of all of their support that there is such a thing as a free lunch, which you'll be having later. So thank you very much. Now, of course, behind any event of this type wouldn't be possible without the logistical, organizational support from so many people. And there are 2 really that I'd like to highlight. And that's Michelle Lee, who's sitting right there, IP Osgoode IP coordinator, and Mary Barbieri, assistant to IP Osgoode. They're a dynamic duo, and they've worked relentlessly to make today's possible. So a round of applause to them. If I could also single out 3 of my research assistants who are actually with me working on the grant that I've talked about. So that's Spencer Norris sitting right there. So hi, Spencer. Sumaya, Charmine, and also Adam Theophanidis, who will be joining us. So thank you to them. Sean Jackson, who's sitting there. Sean is actually going to be blogging on today's event. And so the conversation will very much continue. Sean was one of my students in the IP intensive class that we held last fall, and he was actually had his internship at Teva. So thank you, Sean, for blogging. And so if you don't get to have your input today, the conversation continues online, thanks to Sean. So why don't we start with the program of the day straight away. As you can see, we have a little bookmark that you can, as a keepsake for you, and the booklet. And you'll see that we have 3 main sessions. And not by accident, we start by the student panel first, and then look to academia and university, and of course, applications in the industry to end things off with some closing remarks, and 2 keynotes. So why don't we start with our first keynote, and here the keynote is really the co-sponsor of today, and that's of course the Canadian Intellectual Property Office. Mr. Sylvain Laporte is at the helm of the CEPO as its CEO and Commissioner of Patents and Registrar of Trademarks, and he started this role from 2011. And one of his special, I think, qualifications, which is not in his bio, is that he's also a very much loved IP Osgoode Advisory Board member. So we're very lucky to be able to work with him at IP Osgoode and to welcome him today. Now, previously, if you look at his bio, he's been all over the map in government, at Industry Canada. Before even joining the public service, he was at Canada Post. And what I really like is that he was an aerospace engineer for over 20 years with the Canadian Forces. Now, I think that's pretty cool for the head of CEPO to be doing that, and also to have earned a bachelor's degree in computer science from the Collège Militaire Royal de Saint-Jean, and a master's degree in computer engineering from the Royal Military College in Kingston. Now, his talk will kickstart the day, and he'll take us through some of the global and domestic initiatives here in Canada, and really take us through this cycle, this innovation cycle. So from the idea, the invention, to the commercialization stage, and also talk to us about some of the initiatives that are currently at play in government. So with that, a very warm welcome to Mr. Sylvain Laporte.
Thank you, Pina. If you don't mind, I won't be using the lectern. It makes me a bit uncomfortable when I don't have direct access to the folks in the room. So to the camera operator, you're going to have to follow me because this is going to be interesting. So thank you, Pina, for the introduction. Yes, I do manage the Canadian Intellectual Property Office, and I am new to IP. So this has been an awakening moment for me, and what a wonderful opportunity and discovery it has been. So in all of my dealings in my previous work experience, I've never had to do or to make direct contact with IP, other than when I was in mergers and acquisitions for a couple of years. And because I was the token engineer on a team of lawyers and MBAs, well, guess who had to do valuation on IP? Well, because IP tended to be technical, I used to draw the short straw. And back then, well, I'm going to date myself, maybe 15, 20 years ago, it was not that exciting. Boy, have things changed, right? So intellectual property is now topic and top of mind in a lot of merger and acquisition strategies, and also as part of innovation and commercialization, which takes me here. So, one of the first things I want to convey to you, the Intellectual Property Office has concentrated on being a very, very good intellectual property office for the last many years. My predecessors did a really good job of doing that. So comparatively speaking, when you look at the different countries and the different services from IP, Canada does very, very well on the IP front. So when I come in, I have the luxury of being able to build on a good organization and actually expand, build from that to expand our leadership role. So this new vision that we have is one where we're going to be taking the IP framework from being, or taking my organization from concentrating on being a good IP office to actually expanding and taking a leadership role and making sure that the entire IP framework in Canada is leveraged so that we can look at getting economic gain from it, so that we can look at spurring more and more innovation from the IP perspective. So it is a different role. Not to say that we're going to be minimizing our bread and butter, which is looking at applications. In fact, we're spending a lot of time making sure that we do that well and that we continue to improve in granting those services. But the new twist is we're now very much interested in spurring innovation, commercialization, for the purpose of economic growth in Canada. So let me give you some context before I get into some of the stuff that we're doing to spur commercialization. As you can see from this graph, IP in Canada is growing. We're not growing fast, but like many other countries, we're seeing constant growth over the years, in the order of about 2%, 1%, depends on the year. Patents have seen a bit of a downplay, a bit of a reduction over the last few years, likely because of the global recession, and like everything else over time, it'll probably pick up. So we're in a healthy situation where we're seeing constant growth over time. Now, that being said, we shouldn't probably conclude that everything is okay from that perspective, because let me show you a few more slides. This is the breakdown of where Canadians apply, Canadian businesses apply. Okay? The straight line, not the straight line, the full line at the bottom indicates Canadians filing in Canada. So you can see over time, slight growth, but probably a flat line. So Canadians applying in Canada, pretty constant. And it's not a whole lot. Canadians applying abroad, well, you can see the dashed line, that's growing quite fast. So when we're looking at that, we're asking ourselves a whole bunch of questions that we didn't ask ourselves before. Questions like, okay, so Canadians are filing elsewhere, likely into areas where they're predicting their market is going to be, so that's a good thing, okay? But what about Canadians filing in Canada? If that's flat, what does that mean from a commercialization point of view? Can someone conclude from this that we're not seeing all the innovation that we should in Canada? Well, probably not, but we've never looked at it. Right? So what about commercialization and then, the take-to-market activities that usually come with commercialization, right? Which is usually good for the economy. Can we conclude from this slide that if Canadians are doing their IP elsewhere, that they're also taking their business elsewhere? Don't think so, but we're curious. So we're working with some research folks to try to get to answer some of these questions. And we'll get the results in a year to 18 months, and it's going to be quite revealing with respect to this behavior that we have here in Canada of filing elsewhere. That being said, when you look at the total holdings of Canadian patents, you can see from this slide that relative to rest of the world, the proportion of Canadian holdings to the global holdings is steadily going down. Now that's a bit more worrisome. So remember the first slide, we're growing, but we're not growing fast. Well, apparently from this graph, one could conclude that the rest of the world is growing a lot faster, which means that relative to the rest of the world, we're going down, right? Does that mean Canada is less innovative? No, we know that to be not the case. Is it a cultural thing with respect to IP? Possibly. So other questions that we're asking ourselves and that we're going to look into. In the old days with our previous vision, we were not concerned with these kinds of trouble, of issues and problems. Given our new vision now that looks at innovation, that looks at economic growth, we're now into this kind of thinking, this kind of analysis, and this kind of research. So it's quite exciting for us to be in CIPO at this time. We did get some results from some analysis we've done with Statistics Canada. So we asked them, go out there and talk to universities, businesses, individuals, and get a snapshot of IP out there. Who's using it, who's not using it, by industry, by demographics, by business maturity, and it was quite revealing. The study basically resulted in one key figure, which is that only 15% of businesses that do research and development in Canada use IP. The other 85%, well, the slide says 84%, so 16% and 84. The other 84%, they don't use IP. So why is that? That's substantial. That's a lot of companies that don't use IP. So we've talked to them, and I have a slide to discuss that a bit later on. But we've asked them why, and we got all of the reasons. It's too expensive. It's too lengthy. Even if I get taken to court, despite the fact I have a patent and it costs me a lot, I'm going to lose, or I'm not even going to go to litigation because I can't afford it and all that kind of stuff. So we got all sorts of reasons. What we also discovered was a lot of the reasons were based on misperception, non-fact-based understanding. So clearly we're going to be spending a lot of time with businesses that don't file IP in Canada to raise the level of education and understanding. And that hopefully will spur new business. Now, don't get me wrong, I'm not into the world of convincing people that whatever they're using today, trade secrets or whatnot, is bad. It could be the perfect thing for them. right? Trade secrets are good. So I'm not necessarily into the world of having a conversation with them to convince them to file for trademarks and patents. Absolutely not. My interest in having more discussions with them is to make sure that they are in the proper frame of mind and a knowledgeable position to make a decision, an informed decision, on whether they should file for IP or not, and how IP could or not help them. And one of the bigger discussions, or one of the key topics we're going to have with them, is all about collaboration, right? And if you're going to be collaborating with your technology to commercialize it, to take it to market, to refine it, or whatever, trade secrets may be an issue there, may be a bit of a holdback, right? So we're very interested in looking forward to having those discussions with them. I never realized I had switched my slide. Oh, I did not switch my slide. So that being said, that 85% for us now is a new target, okay? And with that new target, our approach basically is going to be all about awareness and to look at whether or not they can use or leverage IP to become more competitive. With respect to universities, I had built this slide before I saw some of the panel's discussion topics, so I won't spend too much time with it. I just want to leave you with the understanding that we thoroughly understand the contribution universities make towards innovation, and it's substantial. I've met with probably a dozen or so of the directors of the various technology transfer offices of the different universities in Canada, and we're engaged now with the ACCT to continue that dialogue. We're going to be holding roundtable discussions with the technology transfer offices to identify what it is that we can do to help. Right? If I have to change my practices in the office, we have to change regulations or whatnot, we'll change them. So we're now going to engage into that discussion to see how we can be more helpful and to ensure that the technology transfer activities of the innovation continuum is as successful as possible. Speaking of continuum, there are various models of innovation, and I guess we all should understand that innovation is not linear. It can be very cyclical. There could be all sorts of loops and all sorts of ways to maneuver. This is linear, but it's one of the models that we sometimes use. And as you can see from here, if one was to take a purely classical view of university-type research, one would be led to believe that universities are limited to the first two chevrons. We all know that's not the case, right? And good for us, good for Canada, good for the economy. Universities now are active in the entire dimension that you see there, in all of the chevrons. So I'm really glad that we're having this conference about commercialization. You're focusing on the last three of the chevrons, but from someone who's very interested in economic growth, commercialization is about economic growth, right? This is about the take-to-market activities. It's about investment into, building a new plant, hiring new employees, training new employees, capital investment. All of those are part of the economic engine. So you can see that we're very, very interested in making sure that IP, which is present in all of the chevrons there, that IP supports the activity of commercialization. In fact, we're looking at making sure it encourages it and makes it simpler to get at. With respect to collaboration, remember when I spoke of the 84% of businesses that don't use IP? I think it's essential that in our conversations with them, that we make them understand that if you do use IP, or if you do formalize, your intellectual property one way or another, it facilitates discussions on collaboration, and in particular with universities. So if you've been involved in a collaboration activity with, from a university perspective, with small business, you've seen, you've heard that a few very, very good ideas were left on the table. People walked away because they couldn't agree on the intellectual property agreement. So that, to us, is a very big challenge. Don't generalize. It doesn't happen all the time. We have some very, very good success stories on exceptionally good collaboration. But I guess being, the optimist, when someone leaves a good project on the table, it's not something that you like. So we'd like to make sure that none of them are left on the table, that we take every opportunity possible to look at commercialization. Clearly, you can see from my discussion that I'm a bit passionate about commercialization, about innovation. Luckily, I'm not the only one. It is a government priority, and there are many, many people working in this area. Of note, and recently, we've had a committee of parliamentarians look at intellectual property and its contribution to Canada. So, not being from Ottawa, I should let you know that a parliamentary committee is a very, very important committee of elected officials. You may have seen them on TV, because it's often televised. It's when, you have parliamentarians in a U-shaped table, and there's someone in the middle who gets grilled with a whole lot of questions. Well, that's what a parliamentary committee is all about. So one of the very important parliamentary committees called INDU, which is Industry, Science, and Technology, they've concentrated their efforts from May to last week on looking at intellectual property, and they issued a report just this week. So if you're interested in the report, because they have talked to many, many witnesses, and many of them came from the academic and university environment. It's a good read. It's a very neutral report. It comes out with a number of recommendations. What I very much appreciated from the report, the recommendations are in line with encouraging innovation and economic growth, and you see a few of them on the slide there. One particular point I'd like to bring to your attention is the last bullet. So as I said, the committee spent a lot of time with witnesses that came from academia, witnesses that came from the technology transfer organizations, and they recognize that there's some work there. There are challenges in the area of technology transfer, which, if we can surmount, will be facilitating more and more commercialization as we go forward. With respect to the last bullet, and when we talk about or concentrate on the contribution of students to commercialization, clearly with the last bullet, I'm hopeful that students will be able to contribute to, making sure that we reach that objective. CIPO, my own organization, with our new strategy, we've reoriented our efforts to ensure that we look at encouraging innovation and economic growth by leveraging IP. So we're doing a whole bunch of new things that we did not do before. So just to highlight a few, we're now having or engaging in multiple conversations with our customer. We didn't do that before. We didn't talk to innovators. We didn't talk to universities. We didn't talk to businesses. We didn't talk to marketing folks doing take to market. Now we are. So we're meeting one-on-one with the larger companies, and we're holding roundtables to speak to the small businesses. And as part of those roundtables, and yesterday I think we held table number 32 or something like that, we hold them across the country, and we do them in waves. And every wave has a particular theme. So now we're in the third wave, and we're looking at the application process itself, okay? The first waves, we looked at what leads you as a small business CEO to come to a decision to use IP or not. And that was quite revealing. So we have a very good idea as to why they don't use IP, And those that do use IP, we know what their business expectations are of a patent and a trademark. Future roundtables, likely late spring, if we can have a spring, or a bit later on, we'll be looking at the post-application phase. So at the beginning, you had expectations of what your patent or your trademark would give you. We'll be going to talk to them and validate as to whether or not they got those business benefits that they were expecting. So we'll be closing the loop, and that's going to be quite interesting. The idea why we're having these discussions is not just for the sake of understanding our customer, but it's also to take back these business requirements and look at changing our practice. Look at changing the way we do business in the agency, to the point of changing regulations if we need to. Okay, we have very archaic regulations, still talks about using paper, still talks about codes to reflect color, or hash marks to reflect some kind of form or whatnot. Not very good, right? So we're looking at modernizing all of that. And instead of basing those changes on, I think it's a good idea, as the registrar or the commissioner. No. I want to have a factual business requirement to support the change. Then we can't go wrong. So it'll be very interesting to see where these customer consultations take us. Let me skip access to innovative knowledge and go to the modern IP framework. So we are very much open to modernizing, the regulations and the practices to meet the business requirements. We do a number of things which, not sure is the right thing. I'll give you an example. Small businesses are very, very clear with us. It takes too much time. Way too much time. I'm in a hurry, I've got a business to run, I need my patent because my manufacturer says he's not going to manufacture my goods unless I show him a patent. Okay, so I can't wait 5 years, 6 years, 7 years. I want it and I want it now. That's different. These are conversations with the 84% that don't file, right? Maybe the 15% that do file are not that pressed in time. The 84, if we're going to be making sure that IP serves them well in their commercialization efforts, we have to listen to what they're saying. So it means a new value proposition. It means a new way of doing business in the office. Right? We have an accelerated process. You can get a patent in 12 months. It's not known. Clients don't use it. We haven't been very successful with our marketing campaign to advertise it. So now we are. Every round table, this has come up. And every round table, the CEOs of these small businesses go, what? I wish I had known that, right? So we can do it in 12 months, 14 months. Well, why not sooner? Why not earlier? Right? If you submit a patent to us that is simple, has one claim, as opposed to 199, right? It's going to go a lot faster. But we have to change our value proposition. We have to change our frame of mind. So to those new customers that don't use us because we're not fast enough, we need to find ways of going much, much faster. We need to find ways of serving them in a different value proposition than the one we do today with the 15, 20 pages worth of claims. Good, when you look at claims, you're trying to get the best coverage possible for your client if you're an IP agent. But that takes time. With these folks, there's no time. So they don't care about defense. They don't care about, if my fences are large, I may possibly get a bit more royalty out of it. They've printed their glossies, they hired their sales force, they've trained their sales force, they want to get to market and fast. And the manufacturer is saying, want your patent before I flip the switch. We're not very responsive there. So we are going to look at modernizing our IP framework to account for those kinds of business realities. These last two initiatives that we have in the office speak basically of the fact that, from our bread and butter perspective, the application process, there are ways, there are best practices that we'll be able to get at to greatly improve the turnaround time, to greatly improve the quality. So we're putting those practices into place. Right now, I should let you know that, if we look at the average turnaround time for a patent application in Canada, all technologies consolidated, it takes about 50 months on average from you requesting that we evaluate, not from the application date. And from application to you requesting that we evaluate, you can have up to 5 years. I don't count that. So from the time you tell us go to the time a decision is made, 50 months. Our trading partners are around the 30 to 33 month time frame. Well, clearly, we should at least be at par with our partners. So that requires regulatory changes, legislative changes, but it also requires us making sure that we're as sharp as possible with respect to our internal operation. So we're committed for the next 3 to 4 years to put a lot of effort into doing that. So that being said, I'm quite excited that we're having this conference on commercialization. It's very, very important to us. You'll be hopefully seeing a whole lot more of us if you stay into that innovation commercialization theme, because we expect to be taking more and more of a leadership role in that area, because I truly am convinced that IP can be an exceptionally good enabler to commercialization activities. So thank you very much.
Big thanks to Sylvain.
Pleasure.
For animating this discussion and for really kickstarting it. I think you raised some key issues that we hope that during today's panels we'll pick up on some more. So thank you, and look forward to welcoming you again as we continue the conversation. So thank
pleasure.
you from us.
Thank you very much.
Good. Thank you.
Thanks again.
All right.